Thank you for joining our Iowa Mock Trial Competitions Judges Briefing. So we'll start by talking about the students themselves. Each team is going to be made up of 8 to 10 students. That's going to be 4 attorneys, 3 witnesses, 1 timer, and 1 to 3 alternates. You may occasionally see a team with 11 students. The first thing to do is check with the students and see if they have an exception granted by the tournament director. If they do, then everything is good. If they don't, then you should take the issue to the tournament director. Each room is going to have 2 to 3 judges. In an ideal world, we will have 3 judge trials for every student. Unfortunately, we don't live in an ideal world, so we typically have 2 judge trials. If you are lucky enough to be in a 3-judge trial, then one of those judges is going to preside. That judge can decide to fill out a ballot if they would like. That ballot will not count toward the overall result unless there is a tie. The other 2 judges will be our scoring judges. In a 2-judge trial, 1 judge is going to do double duty. They will both score and preside, and the second judge will simply score. The presiding judge is going to conduct the pretrial conference, rule out objections, keep the trial moving, and handle any rule violation discussions that may pop up. One quick note, there are no motions allowed in mock trials. So if you get something like a motion for directed verdict, you can simply deny it. During the pretrial conference, the students are going to introduce themselves. They'll give you a roster that tells you what student on their team is playing which part so that you can fill out your comment forms online or on paper, and you can get the ballots in the right order for the witnesses, our electronic ballots. They'll likely also give you a trial notebook. That trial notebook will probably have the complete case file, the rules of evidence, the rules of procedure, and any other documents the students think you should have in there. The students may want to go over some stipulations. They may want to go over enlargements or exhibits. It's a very good idea to make sure that you do go over the enlargements and demonstratives. Just make sure both sides have seen each other's enlargements or demonstratives, and make sure there are no rule violation questions. If it's an issue of whether it's hearsay or relevance or something like that, that can be dealt with in the trial. If it's an issue of whether it's the wrong size, it's not permitted, something like that, this is the ideal time to get that taken care of. The students will also address whether the witnesses are to be sworn in individually. It's up to the presiding judge whether they want to swear each witness in or prefer to simply declare that all of the witnesses will assume to have been sworn. The students will also ask for permission to use the well. Please do grant that to them. They are in a standing jurisdiction under our rules. It can really handicap the students if you tell them, nope, we're going to sit in this trial because that's what you're used to in our courtrooms. They have been trained in a standing jurisdiction as part of their scoring rubrics for them to be able to properly handle the well, handle enlargements, that kind of thing. So please do give them that permission to use the well. The rules require that the plaintiff or prosecution reserve any remaining time from their closing to use it for a rebuttal if they're going to want to do that. They can do that either as part of this pretrial conference, or they can do it before they begin their primary closing argument. Videotaping and photography, it's always a good idea to check in on this with both sides, particularly if you see a camcorder set up somewhere in the room. The rule in mock trial is very simple. If one side says no, then there is no recording. Oftentimes the issues comes up if someone wants, to record for grandma or a parent's out of state or something like that. But many of our schools have very rigid directions from their actual districts on whether they can record. And so our default rule is that everyone has to consent or nobody's recording. So if you do see a camcorder in the back there, or you see parents with cameras or look like they're taking a recording with their phones, it's a very good idea during this pretrial conference to just get both sides to state on record that they agree that recording can occur. It's also a very good idea to remind everyone to turn their cell phones off. Objections. The students are timed for every element of their case. You, as the judges, do not have to keep track of that time. That's what the students' timekeepers are for. However, when there is an objection, the stopwatches stop, and that does not count against the student's time. The students are not permitted to make objections during opening statements or closing arguments. They are allowed to tell you after the statement or argument if there are any objections they would have made. No ruling should be issued on those objections, but you certainly can and should take them into account in scoring if there were legitimately objectable things in that statement or argument. Objections during examinations can only be made by the attorney on the opposing team that is actually directing or crossing that witness being examined. Typically, when you see an issue with this, it's going to be some of our youngest competitors, often at their very first tournament, and they just get excited. And they hop up and they just don't think it through. So typically what I will do is I will first warn everyone and remind everyone that only the student handling the examination can object. And that will usually take care of the problem. We don't typically see any kind of persistent issues with this. It really is an enthusiasm issue most of the time. If the students need some help from their co-counsel to come up with a response to an objection, they certainly can confer with their co-counsel, but then those stopwatches are going to restart, and those conferences with co-counsel are going to count against their time. I also personally try and keep those students to 15 seconds on those, right? Like, it's really going to drag the trial down if they are sitting there going over the written rules of evidence, just trying to find the answer. This is designed to give them, oh shoot, I know we know this. Hey friends, can you tell me? Not, we're going to sit here and research the rules for 3 minutes. So do just try and keep those moving, but be aware that that does count against the student's time for their element, unlike the overall objection discussion itself. Ideally, we would also stick to one response per attorney. So you're going to have your objection, the response, and then a rebuttal. Some of our very well prepared students who have done this for quite a while, they can argue the rules extremely well, better than some attorneys. And so it can sometimes be really interesting to see how far they can go. But we do want to be mindful of the fact that we need to keep the trials moving, and ideally we would keep it to this objection, response, and rebuttal. The students have their own rules of evidence, which are derived from our rules of evidence. They do have fewer hearsay exceptions under Rule 803. One common one is public records. So if you're looking at a document thinking, gosh, why didn't they argue public record? Well, they don't have that exception. So if there's an exception you've got in mind, feel free to take a peek at their rules of evidence and just see. It may be one that they have and they missed it, and that would be absolutely appropriate to account for in your scoring. It may also be that they just don't have that exception, and so they don't realize it's out there because for them it doesn't exist. They also do not have the same authenticity rules that we have. Generally, there's going to be a stipulation that says authenticity is assumed for all of the exhibits. They also have some additional rule numbers in the 1100s, and those are just going to formalize some things that we object to, like speculation. And then there's an additional important rule called unfair extrapolation. And that's Rule 1107 of the Iowa Mock Trial Rules of Evidence. The purpose is to prevent teams from inventing material facts on direct examination. Material fact is a fact that affects the outcome of the trial. And that's really what you're looking for to violate this rule. Cute background information, funny jokes, that doesn't violate this rule. What violates this rule is the students coming up with a fact out of thin air that's not supported in the case materials, particularly not in the case materials that witness would be familiar with. And it could change the outcome of the case, okay? So if that student's affidavit and any exhibits that student is familiar with would not support them knowing that fact or the existence of that fact, and it could change the outcome of the case, that is an unfair extrapolation. Typically, students are going to be trained to try and deal with this through impeachment on cross-examination, but sometimes you will see teams that will object to it as a violation of Rule 1107. If you do receive an objection to it, you can handle it one of two ways. You can reserve ruling and tell that opposing attorney you're looking forward to their impeachment on cross. You could also hold a bench conference. And if you do that, you're going to have the two attorneys who are handling that examination come up to the bench, and they're going to point out to you in the affidavit and other materials where they think there is support for this or not support for this, if it's a wholly made up fact. And then you can rule on whether it's an unfair extrapolation or not. Each judge would then take into account on their own ballots how they think that affects the points for the students handling that exam or for the witness doing that exam. If you do reserve ruling and request an impeachment on cross, then obviously it likely won't be a formal ruling on it, but each judge will take into account on their own ballot whether they think that was an effective impeachment and whether there was an unfair extrapolation. Every trial round is going to consist of a pretrial conference, opening statements by both teams. The defense does not get to reserve their opening statement. They do have to go right after the plaintiff. You are then going to see the plaintiff's case in chief and the cross-examinations of those witnesses. There will always be 3 plaintiff or prosecution witnesses. The students will likely request a short break at that point. Typically 5 minutes is appropriate, but if this case is running on and on and on, use your best judgment. You're then going to see the defense case in chief and the cross-exams of those 3 witnesses. Then there will be another short break, often 5 to 10 minutes, kind of depending on how the trial is going. And then you'll hear the closing arguments from both teams. Like we discussed before, the plaintiff or prosecution has to reserve time for their rebuttal out of their total closing argument time. If you do have a situation that comes up where a plaintiff or prosecution forgot to reserve that time, it is up to the presiding judge in that room to resolve it. Read the room. Do you think this was some kind of intentional gameplay? If so, maybe deny them their rebuttal. If this seems like a genuine, forgetfulness issue or a really young, nervous teen, you certainly can still give them the right to do their rebuttal and use their remaining time. The time is still there. What I have usually done when this has come up in my courtrooms is I will turn to the defense and I will ask them if they have any objection to the plaintiff or prosecution using up the rest of their time. And every round that I have done that, except I think one, the defense has said, absolutely, they can go ahead and use their time. And so what I've done in that situation is plaintiff gets their rebuttal, but defense is going to get a bump from me on their team score because that's a real example of collegiality. If the defense says, no, they didn't reserve their time, we would object. I typically will then tell prosecution, I'm sorry, you don't get to have your rebuttal. You did not reserve your time, unless this is like scared 6th graders being beat up on, right? Like I might change with them. But, if it's been a pretty fair, pretty even round, I will say, okay, you don't get your time, but then defense is not going to get that collegiality bump from me in their team score. I'm not going to necessarily score them down because they're well within their rights, but I'm not going to give them a bump. All parts of the trial are timed, as I mentioned before. The students know how long those go, and their timers are supposed to be tracking it. If a student timer stands up and says, I apologize, but time has expired or something like that, the first thing you need to do is you need to establish the time actually has expired. If the timekeepers have a difference of opinion on how much time is remaining, the judge who is presiding is going to make a decision. Frequently, when we have that kind of issue, it turns out that one side wasn't stopping the stopwatch on objection battles. And so the stopwatch was allowed to run when it shouldn't have. But use your best guess, talk to the timers, find out what they think happened. If they really cannot come to an agreement and the side that claims you're out of time is not budging and they're like, no, I've been stopping the stopwatch, then it's up to that presiding judge to make a call. If you feel, having sat through these exams, that they have not used their time, you can give them remaining time up to whatever the other timekeeper has. You can split the baby. If you feel like this really has run out of time and you've noticed that the timekeeper who claims there is time left has been very disorganized or something like that, you just have to read the room, read the kids, and make the best call that you can. If the teams do agree that the student has run out of time completely, then it is up to the judge whether they allow some additional time. You are not not required to allow extra time. Under the rules, you can give up to 45 seconds, but that can be a huge amount of time in mock trial. Opening statements, for example, are 4 minutes long. So if you give them an extra 45 seconds to finish an opening statement, you're giving them 20% more time. So just use your best judgment. One example I like to use is if it's a cross-examination, right? Is this a situation where the witness on the stand has clearly been trained to ignore any cross-exam control technique that attorney could ever possibly use. And gosh, that attorney has used every cross-control technique that you've ever seen or heard of, and several that you haven't. And it's clear this witness has just trained to be a freight train and just keep talking and run out the clock. If I see that in my courtroom, I might give that crossing attorney 45 seconds, and I might also give the witness an instruction to answer yes or no. On the other hand, if that crossing attorney has been clearly disorganized, they've gone down rabbit holes, they've asked very complex, convoluted questions that can't be answered with a yes and no, or they had a teammate who did all of these things and ate up their time, then I'm probably not going to give them any more time. Or I might say you can ask one question and the witness is going to answer appropriately. You know, a good plan may also be to let the student finish their thought or their sentence or do one question and answer, something like that. Scoring. We do have an electronic ballot now. We will help you in the judges room get onto that and get set up on that if you're having any issues. We do have a few devices available for those who maybe don't have a tablet or a laptop that they can access the ballot on. If you are very uncomfortable with the electronic ballot, we can certainly give you a paper ballot to fill out and you can bring that back to tab, and then we'll be happy to enter your numbers for you if you're more comfortable with that. The scoring is on a scale of 1 to 10 for each student. So each separate and attorney and witness role is going to get a score from 1 to 10. 1 is the worst, 10 is the best. Each team is also going to receive a team score from 1 to 10. That is not an average, that's an overall score for how the team did. And we will talk in a minute here about some more specifics with that. Each team can earn up to 150 points during the round on each judge's ballot. Half points are fine. Please don't go smaller than half points. And actually the electronic ballot won't allow you to do that. The other nice thing about the electronic ballot is that it will score things as you're going. So you can always look at the bottom. It also will not let you submit if you have a tie. It will make you change something so there is no tie. But please do score as you go, even if you're just kind of keeping notes about a tentative score. Don't try and record all your scores at the end of the round. Number one, it slows the trial down. It slows the whole day down, and we need to keep these rounds moving. But more importantly, you're going to forget. It's very tempting to say, oh, I want to see all 3 exams, or I want to see all 6 directs and then score them. And what happens is it all blurs together and you forget what that first one really looked like. So do put down a score, even if you're just keeping tentative scores on a notepad. And then if you need to go back and adjust some scores after you've seen everything, that's perfectly fine. No number is final until you hit the button to submit it to tab. But please do try and keep track as you go. Scoring opening statements. Opening statements are about telling a story. So the student who does a good open is going to tell the story. They're going to introduce the characters. They're going to give you a brief recitation of the law that applies in this case and where the burden sits. And they're going to do this persuasively. And the best ones are going to do it completely without notes. And they're going to do it using the whole well. It's really phenomenal what some of these students can manage to do. But also keep in mind that you can see the most phenomenally presented story or presentation. But if at the end of it, you don't know what this case is about, who's who, or what happened, that is not a good open, no matter how engaging it was to watch. We do have more details on all of these elements on the judges scoring rubric. The students are also provided that, so that's what they are aiming for. So if you have not looked at that rubric in a couple of years or you've never seen it, we would encourage you to take a look at it and just see, because that will help you understand what the students are aiming for with their presentations. For examinations, those attorneys who are handling directs and crosses, we want to see a form of questions that's appropriate to the exam. So on those cross, we want to see those wonderful leading questions. On direct, we want to see those nice open questions that make that witness into a star. We want to see a good flow and logic of the examination. We don't want them jumping around and distracted. Use of notes. It's often going to be very little or no notes for these really good crosses and directs. Typically, good use of notes would be a sticky note with, I heard you say this on direct, or something like that. If you see students, putting their notes down on the corner of the table and sneakily looking down at them, that's not a good use of notes, right? That's no different than having it in their hands. Confidence and presentation are also very important, as well as how they use the well, how they use demonstratives, how they enter exhibits, how they respond to objections. And again, there's more detail on the ballot, or excuse me, the scoring rubric. For witnesses, do they know their stuff, right? Do they know their affidavits? Do they know their facts? Are they telling a story? Are they playing the character in an interesting and believable manner? Hamming it up is not always interesting and believable, right? We want good acting, not bad hammy Three Stooges acting. Is the witness maintaining their character on cross, or are they breaking character to argue for their side? If there's a Jekyll and Hyde personality switch between direct and cross, that's not a good witness. And then please note that use of notes by a witness is a rule violation and should result in a very low score. For closing arguments, are they able to accurately discuss the law at issue in the case? Are they applying the facts to that law? Is it persuasive? Is it confident? Did they use the well in a convincing and good manner? And then how were they using the notes? Was it minimal and effective, or were they kind of reading a pre-made script? Closing is another area where it's important to remember that you could see this phenomenal presentation that, as far as movement and vocal quality and pacing and drama, just knocks you out of your shoes. And then you sit and think and realize they never told me what law applies here. They never told me who has the burden. They never told me that the standard is preponderance of the evidence or clear and convincing evidence or beyond a reasonable doubt. They never explained to me what that means. And it was just this beautiful like recitation of the facts or something like that, with very, dramatic statements of morals and righteousness. That's not a good closing either, right? The ideal closing is going to have that drama, but also discuss the law, apply the facts to the law, and tell you the burden and point that jury where they need to go. That exact same thing we need to do as attorneys in a courtroom. Scoring a team score. The team score should be based on teamwork, professionalism, and integrity. Some examples of these would be, are they setting up demonstratives for each other, more easels? Are they keeping track of where someone is in their outline in case somebody gets stuck when they're dealing with the other team? Are they collegial? Are they respectful when they talk to them? Sometimes we'll see wonderful things like teams sharing easels or sharing demonstratives to make it easier on everybody. And that's amazing to see. How was their overall performance as a group? Were they organized? Were they helping each other? Was the table nice and organized, or was it just a distracting mess? All those kinds of overall big picture issues. This is also a place to take into effect any rule violations that may come up. If a rule violation is brought to your attention, you're going to hold a conference with both sides. Coaches cannot be involved in these conferences. So you're going to need to have a student from each side. Most teams are going to have a student attorney who's kind of their point person who handles a lot of this. They might be the one who did pre-trial, something like that. Some student representative from each side, typically one of the attorneys, is going to need to handle this, not the coaches. If they can't articulate to you why they think it's a rule violation, it's probably not a rule violation. If there is a serious issue and you think it can't be addressed in the courtroom or with point adjustments on the ballot, do bring it to John or the tournament director's attention during a break or after the trial and get further directions. If it is really critical and serious and it happens mid-trial, you can always go to tab and get the tournament director. Those sorts of things are exceedingly rare, however. The most frequent thing we're going to see is, a violation that there's been talking to adults, and we'll talk about that in a minute. Another thing with scoring is that at a regional, the average score is going to be around a 6 to 7. At state, the average score is probably going to be around a 7 to 8. You may see quite a few 9s and even some 10s at state as well, or possibly even regionals. We do ask that you keep the scores as much as possible above a 5 though, and reserve that 1 to 4 range for students who are not taking it seriously, who are not prepared, who are mocking the process, or who have rule violations. Just because these are students and they're learning, and it's frankly amazing what they can present to you. So we do encourage you, absent those kind of extraordinary situations, to try and keep your scores above a 5 as much as possible. Now, the electronic ballot has an option to nominate outstanding witnesses and attorneys. We do request that you do that if you see those outstanding performances. If you didn't see anything you felt was worth nominating, that is totally fine. There's a place on the ballot where you can indicate that. You can nominate up to 3 witnesses and 3 attorneys per round. Position does matter. So do make sure you're putting your top student in first and second and so on. Do not confer with your co-judge before nominating. This should be each judge's individual evaluation of the performances. After the round is over and you've hit the submit button on that ballot and sent that over to Tab through the wonderful internet, please give the students some oral critique. Do keep your comments big picture. Highlighting particular students for good or bad things generally doesn't go over well, and it can cause some hurt issues. So try and keep it big picture, or even, you know, big picture to each team. Do try and keep your comments positive overall, but don't shy away from constructive criticism. Negativity is not helpful, but constructive criticism, things that the students can improve on, particularly anything you see that's a small step they can apply in their next round that might be helpful, that's always much appreciated. Do also please try and keep your comments to about 5 minutes per judge, just so we can keep the rounds moving. Some additional differences from the real world: students are not permitted to talk to coaches or any other family until the round is over, and that includes the breaks. This is to prevent any mid-round coaching. This is the most frequent rule violation allegation that we see. The vast majority of the time, what has happened is that someone's grandparent or parent or cousin or something like that has gotten very enthusiastic and excited, or they need to leave early or something like that, and they come up on a break and they give a big hug and "you're doing great, honey," and that kind of thing, and the other side sees it, freaks out, and alleges the rule violation. So if there is an allegation that students have been talking to an adult, you're going to have a conference about it, like we discussed with any other rule violation. You're going to let both sides explain what happened. Typically, that is what it is, and if it is something like that, then you're not, personally for me, you're not going to punish the student for grandma coming up to them, right? And it is often grandparents. If there is a real serious consideration that there may have been some coaching going on, that's a different situation, and you can either deal with it in room on the ballots, or you could bring it to the tournament director's attention. The other time we sometimes will see some issues with this is if a student is sick, but we have many wonderful coaches. And what often will happen when a student is sick is that the coach on the opposing side will say, "Hey, go take care of your kid, not a problem. We know you're not coaching them. They're puking in the bathroom," right? If there is some sort of concern, or a coach is really worried about what's going on, typically the coach who has the sick student is like, "Hey, you're welcome to come in the bathroom and be there with us, you know, outside the stall." And make sure you can hear that I'm not coaching this kid. But our coaches generally are very good about that kind of thing. They're like, "Go take care of your kid, not an issue." But if you do have a situation that comes up, do try and deal with it in courtroom. If you feel that you can't, do come get the tournament director. Sequestration is not allowed in mock trial for these students. That's sequestration of witnesses. That's both real or constructive. So witnesses are assumed to have sat through all examinations, because they do. The other thing is that cross-exam is always an open scope, but redirect and recross are closed in scope. They also only get one redirect and one recross per witness. So no re. They get one re and they're done. And again, as we discussed before, we are a standing jurisdiction. And finally, I just want to say thank you so much for volunteering your time to judge. The judges are the ones who make this program possible. We appreciate all of our judges, but we particularly appreciate our attorney and judge and retired attorney and judges who come and work with us, because that makes the situation just all the more special for the students. We've done some math, and we've calculated it's roughly $500,000 of donated time over the course of a full mock trial cycle of both tournaments and both state tournaments. When you take the average attorney billable hour rate times the amount of hours we need covered for judges, and that doesn't even take into account our attorney coaches. So we greatly appreciate everyone donating their time, and it really makes the students' day so much better to have judges in the room. If you have any questions about judging mock trial, please feel free to reach out to me. I'm Christina Thompson. I'm one of the current co-chairs for mock trial during the high school 2022 season. My other co-chairs are Amy Mapes, Aaron Jones, and Olivia Brooks. You can also reach out to any of them if you have questions. You can also feel free to reach out to John Wheeler at the bar. He runs the program overall, and any of us would be happy to help you with any questions you have. Starting with the middle school 2022 season, Amy, Olivia, and Aaron will be the mock trial co-chairs, and they and John will be happy to answer any questions you might have. And once again, thank you so much for judging.